In this video, Ripple strikes back in a big way. Let's go.
And now, the XRP Minute with Chip on the chain.
Chip here with the XRP Minute. If it's your first time here, like, subscribe, click that notification bell. You'll be notified anytime we drop a video. The best way you can help us out here, share this with your friends, your neighbors, anybody, your enemies. I don't care. Share it with somebody. Now, Ripple is responding to the SEC. We know that the SEC dropped on December 31st, 2020. They dropped a complaint against Ripple as Jay Clayton, the ex-chairman, I should call him, of the SEC, he left the following day. So let's jump in to the shallow end head first for maximum impact. This was filed. This is just a disclosure. It says, pursuant to Federal Rules Civil Procedure 7.1 and to enable district court judges, 7.1 rule just states whether you're a public company or not, and also if there's any parent company or stock disclosures. And this says Ripple is a Delaware corporation. Its principal place of business is in San Francisco, California, and Ripple has no parent corporation with no publicly held company owns 10% or more of Ripple stock. Simple disclosure here. Now, John Deaton, who filed on behalf of the XRP community, he dropped it in the wee hours of January 1st, 2021, and he took a look at this as well. He said, Ripple responds that I've been asked to provide my thoughts on Ripple's answer. Quickly looked over the answer late last night, 93 pages, spent less than an hour reading it, so please take that into consideration. Plan to read it more in detail over the coming days, and I'll revisit these initial thoughts. Before I provide any thoughts, I should warn you that if you ask 3 different attorneys to respond, you're likely to get 3 different opinions. And of course, I have my own opinion here. So I also provide my honest assessment even when I know it's not what people want to hear. Personally, I was disappointed in the answer. My disappointment means nothing and has no impact on the issues. In fact, if this case is going to trial, I would have advised Ripple to answer the complaint much like it did. My disappointment isn't reflection regarding the skill of Ripple's trial lawyers or in-house counsel, Stuart Adirati, or regarding the merits of the defense. Ripple's lawyers know much more than I do in respect to the securities laws. I'm disappointed because after reading the answer, I'm less confident that a settlement will transpire within the next 6 to 9 months. Instead, it looks like there might be a very long legal battle ahead. There are 2 ways to write pleadings in court. One way is what's called a notice pleading. All you have to do is provide a minimum amount of information necessary to provide adequate notice of the charges or the defenses. The second approach is what's called fact pleading or evidence pleading. With fact pleading, you provide not all, but a lot of the evidence you intend to rely on to support the charges or defenses. For example, Ripple's second affirmative defense is that XRP is not a security or investment contract. Except for a few sentences in the answer, Ripple doesn't allude to the many examples of the use cases demonstrating that XRP is, in fact, not a security. For instance, it doesn't list how XRP is being used as payroll currency in Japan or elsewhere. Ripple, however, was under no obligation to do so at this stage because all that's required in federal court is to provide notice of your claims and defenses. It's not required to plead some sort of evidence that you rely on at trial. I thought it might be possible that Ripple might front end the evidence in an effort to drive home the absurdity of calling today's XRP a security. Strategically, Ripple decided not to go this route. My speculation is that people knew that it wouldn't make any difference to the SEC based on their negotiations and decided to strategically hold information and evidence back to unleash at a more appropriate time later. That was my assessment too. It's going to be just some overall facts. This is just me putting my 2 cents in. And in short, why show your hand until you're required to do so? Totally agree with that. No need to give your opponent a heads up on your strategy or arguments. Absolutely agree with that. It's usually the best strategy to employ when you realize that your case is likely going the distance. There's no doubt that some of the XRP haters will argue that Ripple's answer didn't prove the SEC's allegations wrong, and Ripple admitted to certain distributions of XRP. No shit, Sherlock. Ripple has distributed and sold XRP at times at a discount. That doesn't make it a security. Most importantly, Ripple doesn't have to prove anything yet. The SEC must prove that XRP is a security. All Ripple had to do thus far was answer the complaint. And that's exactly what they did. Ripple simply provided notice of a few basic arguments and defenses it will rely on. One, the SEC lacks the proper authority to regulate XRP. Two, there's no regulator in the space or in the rest of the world that claims XRP as a security. Three, US government's already classified XRP as a virtual currency in 2015 and in 2020. Four, XRP is exempt from the Securities Act because its functional equivalent of the currency is that it acts as an SOV medium of exchange and a unit of account. Five, if it's not a currency, then it's a commodity like gold, silver, oil, or Ethereum. And I want to circle back to this point. One of the reasons I wanted to read this, because I think John Deaton is somebody who gives a very good, I really kind of heavily side with his opinion and what he's looking at. And I know there's some other attorneys in the space that do a great job too. But again, like John said, it's just a matter of opinion, right? You ask three different judges to settle a case. That's why they call it they write opinions, right? Opinions based on interpretation of law. Lastly, the SEC should be barred from claiming XRP as a security because it violates fundamental fairness, due process, and fair notice. I find this defense, it's titled in the fourth defense in the complaint, very intriguing. I'm sure Ripple's lawyers will be armed with case law that supports an argument that the government should have stopped from making this claim at the point in time. In a previous tweet, or when I was on the chain or on David Gokhshtein, I referred to this type of argument by alluding to the doctrine as equitable estoppel. And that was something John brought up very early. We had him on the show, on a live show, which is on the other channel. By the way, click below, you'll see the link down there. And then basically that doctrine protects one party from being harmed by another party's conduct, voluntary conduct. That conduct may be an action, or silence, or acquiescence. The doctrine is rarely used against a government entity, and I'm not saying that it specifically applies in this case. I'm only explaining that Ripple's lawyers have encapsulated that concept or doctrine and weaved it into due process, fair notice argument, brilliant. Using the 2015 DOJ and FinCEN settlement with their classification of XRP as a convertible virtual currency, coupled with the SEC allowing the XRP to be openly traded along with Bitcoin and Ether for about 8 years, gave any person or company the reasonable belief that XRP would not be prohibited. In short, under the law and circumstances, Ripple lacked fair notice that its conduct was prohibited. If Ripple lawyers are able to provide case law and precedent that strongly supports this argument, they will have the SEC backpedaling during the case. Anyways, these are some of my initial thoughts after the first read of the answer. There's much more to unpack, but that's for another thread. I want to thank John for putting this out there just because I think it's very well done. And I do think that what he's alluding to here and what he's talking about as far as the strategy is spot on. You don't have to show your cards in this at this time part of the game, right? So at this point, at this juncture, if you don't have to show your cards, why put them on the table? And that's what John's brilliantly laying out here. And I also read through everything too. And you could say, well, you should have said this, or why didn't you talk about this? If this is going to go the distance, there's no real need to do that. But I think one of the things that I picked up on this thing is something pretty interesting, and I've been talking about this for a while too, that Ether, the cryptocurrency, was deemed not a security, right, along with Bitcoin. However, some of the things that we brought up on the show, and I brought up specifically, was the fact that in 2015, Vitalik Buterin very publicly acknowledged and thanked a particular investor in the space. This particular investor, I don't name the name, you can do after do a Google search. One of the things we found out was thank you for basically saving the foundation. And because enough was purchased, to me, I'm not an attorney. John Deaton's an attorney. There's plenty of great attorneys out there. But to me, you got to look at this in one simple way. Is like, okay, so they did sell an unregistered security. That's never mentioned. There we go, right? So Greg Kidd tweeted this out. He says, Ripple's getting out in front of defining the issues through its Freedom of Information Act request with the SEC. He hit it up with this thread, forcing the agency to reveal why it's picking winners and losers rather than putting out clear guidelines and sticking to its mission. And its mission is protecting you, the investor, right? That's really what the SEC in the United States is all about. It was set up to protect the investor. What are they doing? They're litigating. Did they ever provide clear guidelines? They didn't. This is what Greg's so brilliantly alluding to here. He says a lot with a few words, and I really have a lot of respect for Greg Kidd too. You know, former back of the day. You know, of course, he was one of the originators and one of the founding team. He says score one for transparency. So I want to unpack this a little bit because I want to go into this here. Let's go into this FOIA request. So a FOIA request, let's look here. This is a Freedom of Information Act. This means that you, as a private citizen or entity, you can go out there and you can request from the government in a formal letter that you would like to have access to something that may not be public, right? So there's Freedom of Information Acts around everything. It really is there to provide some transparency, and some Freedom of Information Acts requests take years. You know, it gets lost in the shuffle, and they don't really want to get the information out there. But I wanted to go through this because I think this is going to reveal a lot about Ripple's real strategy. The Freedom of Information Act request for records relating to Ether determination and letters regarding the Chinese control of cryptocurrencies. This letter constitutes a request pursuant to the Freedom of Information Act, 5 U.S.C. 55, and implementing regulations. Now, the background, determination that Ether was not a security. So what they're looking at here is they want to go ahead, they want to get everything related to how did the SEC arrive at this particular idea that Ether is not a security. So originally conceived by Vitalik Buterin, Ether is a native digital asset of the Ethereum blockchain. Buterin published the Ethereum white paper back in 2013, endeavoring to create an alternative protocol for building decentralized applications. Ether is necessary to perform any actions on the Ethereum network. Using an Ethereum application or sending Ether on the blockchain requires the payment of a small fee in Ether. So, well, a small fee can be debated, right? I mean, those gas fees can be pretty heavy at times. In the Ethereum system, transactions are monitored by miners who receive payment in small amounts of newly issued Ether. Now, we know that Ether 2.0 is in process, but however, we're going back to the beginning. So since 2014 of July, the Ethereum ecosystem has been supported by the Ethereum Foundation, and it's a nonprofit organization which claims to be one part of a much larger ecosystem that funds development of the Ethereum-related technologies. Through the Ecosystem Support Program, the Ethereum Foundation gives grants to support projects such as Uniswap, an automated market maker, or Ethers.js, a JavaScript library, which is designed to interact with Ethereum. Ethereum Foundation provides financial and non-financial support to the Ethereum community in order to accelerate the growth of the ecosystem. The website of the Ethereum Foundation, ethereum.org, educates the public about the Ether and directs visitors to where this can be purchased. Now, why are they going into all this? Well, they're sort of laying out a story here. And what they're saying is from July 22nd, 2014 to September 2nd, 2014, Buterin and Ethereum Foundation conducted a fundraising sale of pre-mined Ether tokens. The Ether purchase was not usable or transferable by purchasers at the time of sale. Instead, purchasers had to wait until the launch of Ethereum on July 30th, 2015. That smells an awful lot like an initial coin offering, doesn't it? An ICO, huh? SEC's not real big on ICOs, but that's kind of what happened here. Why? Because they weren't able to use it at the time. So they go on to say the Ether was sold by Ethereum at a discounted price during the 42-day fundraising sale. Fundraising sale. The Ethereum Foundation sold 60 million Ether to the public and raised more than 18 million. 12 million Ether was given to the Ethereum Foundation and other participants. 72 million of Ether was either sold to the public prior to the launch of the ecosystem of the Ethereum blockchain and provided the Ethereum Foundation has a market value today of over 95 billion and represents the majority of Ether currently trading in the secondary market. In addition, the Ethereum Foundation Consensus is a private company founded in October 2014 by Ethereum co-founder Joseph Lubin to focus on further development and advances of the Ethereum software. Consensus' mission was to enable developers, enterprises, and people worldwide to build next generation applications. Are you seeing where they're going here? They're drawing an awful lot of similarities, right? Even though it's a different ecosystem, even though it's a private nonprofit organization, what did they do? So this is one of the things where I think their strategy is pretty brilliant here, and what they're doing, and this is something that John Deaton alluded to pretty heavy in his his real quick peripheral view of just a quick read through. But think about what's happening here. They're drawing parallels. So they went out and they sold something which looked like an ICO, right? Because it couldn't be even utilized, and they pre-sold it from a certain date. They pre-sold it at a discounted amount. So all this stuff ties back to a lot of the allegations of the SEC versus Ripple. So what does that tell us? Well, it tells us that this Freedom of Information Act right here, where is it? Yeah, here we're on it. This Freedom of Information request is pretty interesting and pretty telling. They're also weaving in another part of their defense, which if you're looking at the United States, they're also looking and just kind of slightly putting in there right here where they say also letters regarding Chinese control of cryptocurrencies, right? Just let's highlight that. Letters regarding Chinese control of cryptocurrencies. So when we're looking at this entire thing, we got to look at one thing, and it's pretty simple. The allegations that are levied towards and the complaint against Ripple look eerily similar to something that was already 2+ years ago by now, Ether, Bitcoin, not securities. However, why are they asking for this Freedom of Information Act? Pretty simply, they want to get to the bottom of it. They want to know, how did the SEC arrive at this? Did the SEC take a look at this initial? Well, it wasn't posted as an initial coin offering, but essentially that's what it was, because they couldn't even be used till the following year, as far as having a value and everything else. So they set a preset value on it. They discounted it. A lot of it was a real big investor that came in and purchased a pretty big sizable chunk of Ethereum. And what this awful looks like is that Ripple is striking back. Ripple, when you look at what they have in that complaint, this is what's going on behind the scenes. This is the real meat, as they say, and Ripple striking back, going in, and they are going to uncover, because what they're going to find is hypocrisy. They're going to find the fact that the SEC wasn't up to its mission, and they were not necessarily taking care of you as the investor. They're off litigating. They never provided clear guidelines, and in the end, uncovering this with the Freedom of Information request is going to prove very interesting and very valuable for Ripple. I'm Chip. This is the XRP Minute. Please check us out on the other channel. We do live streams at least 6 days a week. We take off Fridays, but everyone has a life. Anyway, thank you for watching. If you're one person that got here, you rock, and everything is going to be okay. Chill, relax, and have an interesting, it's already February. January was crazy. Strap in, because it's going to buckle up, because February is bound to unleash some craziness. Chip out.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.